Ladies and gentlemen, brothers and sisters, friends, and comrades, I hope you are doing well in this Friday, Furahi day. Come on, join in. I'm going to give you a few minutes to just settle down. I know it's Friday. You're probably somewhere uko kwa bar, uko kwa nyumba, unaangalia Netflix, you unaangalia nini. I'm going to give you a few minutes just to find a sit because this is heavy. This is going to be a marathon as we break down what has happened in Kenya. There's so much happening. I woke up and it was the Senate. It was Assembly, House, National Assembly that was voting voting on the nominee that was presented by President. The nominee who is Kindiki, Kithure Kindiki. But there's questioning lingering on the legal nature of how this thing was done. The nomination that is. Not only that, the whole process by the Senate and the National Assembly before it got there. Well, they voted and they chose and voted to impeach Rigathi Gachagua. That's all in limbo still. I know a lot of people are celebrating, especially people who are anti-Rigathi. That is celebrating that Rigathi ametoka, he's been impeached, it's over for him, whatever. Not quite yet. Bado, still. By the way, there's a conservatory order. That's something that we've been waiting for a while. It's in place. Conservatory order that says, hey, listen, all this matter, hii mambo ya kuweka Kindiki in office, assuming office, should be stopped immediately because there's suspicion of a bunch of illegalities that has been committed by the legislative body, whether it's the National Assembly or the Senate. So there's two conservatory orders that has been given. One by the High Court, one by some court somewhere in, I forgot the name of the place. But we shall break down everything. Leoni Friday, Furahi Day, in marathon. Tafadhali, if you're eating, if you're drinking, if you're smoking, if you're... Karibu. This is Kenya Revolution. Karibu. We want to get loyally here, and we shall use the Constitution to make our case for or against Gachagua or Kindiki. If you're a lawyer in Kenya, or you have some understanding of the Kenyan 2010 Constitution, tafadhali, make your way here because we shall bring you in. We might need to talk about some things. We have snippets of experts. We have snippets of people who are lawyers who might be involved in this case. We shall bring all sorts of people here. Ata Magandawala kama mimi and others, please come in, take a seat. We are about to get started. I shall start with a couple of videos and clips. Then after about 30-25 minutes or so, I shall get to where I bring my view and bring viewers who might be for or against what has happened. But let me say something. I want to focus on the legal nature of whether not only Kindiki was, brought in as a deputy the president, but the illegal or legal nature in which Gachagua was impeached. Because as it stands, from my understanding, if I was to look at everything, Gachagua is still the deputy president of the Republic of Kenya. I will tell you why. But before I get started, brothers and sisters, friends, enemies and comrades, please, I implore you, I implore you, I beg of you, okay? Hit that subscribe button kama huja subscribe. Kama huja subscribe, enda ka subscribe. Subscribes are easy. Ndio tuanze. Na by the way, like the video kwa sababu tutaingia ndani na tutaangalia constitution. We shall look at these articles that you hear wakina Amason King are talking about. We want to break them down to the molecule level and see who's really telling the truth, because there's a lot of politicization, politicized issue, and people are not looking at the legal issue. Because even if you want to achieve a political goal, you have to go to the legality of it in order to achieve it. If you want to be the president, yes, it's a goal to hold a political position, but you will need to see what the laws says in order to achieve your goal. Karibu sana. I see Shimariam, Critical Kaur, and others. Please like the video, share, comment, everything. Let's get started with our round of videos and we shall get to it. I'm so excited today. Go ahead and like the video and share, subscribe, and please subscribe to it. We are about to get started. Tuanze ama tusianze? Haya, nawaona upo Kaur na kuona Shimariam na kuona hapo. Haya basi, tuanze. Tukaribishane. Whether you're on X or you're on YouTube, please go ahead. Join the party. The party is about to start. I say party after party. This is a political party. Not a party in the sense that it's a political party where we have the nation. No, we are about to have a pepper party. We are about to go look at the laws and everything. Okay, have you subscribed yet? Okay, if you're just joining in, go ahead and subscribe to the channel if you haven't subscribed. Like the video, share, comment, and all that stuff. Let me start with the first video of the news of what the court says. Ama mkofiti. Aya basi. Tuanzeni. I won't take much of your time. I won't take your time. Your time is precious. Thank you for joining me. So just go ahead and do me a favor and subscribe to the channel, like, share, comment. Aya, tuanze na video ya kwanza. This is coming from, I think, NTV. Let's go.
Parts of the country in the course of this bulletin. Now, Deputy President-designate Professor Kithure Kindiki has been blocked from assuming office following the ouster of Rigathi Gachagua from the same office. Justice Richard Mwongo, sitting at the High Court in Kerugoya, has further directed that the petition by David Munyi Madenge and Peter Gishopi Kamotho be forwarded to the Chief Justice to form a bench of an uneven number of judges to determine the matter. This in a day of court battles with Gachagua seeking to save his tenure. And TV's senior reporter Ibrahim Karancha reports.
Ousted Deputy President Rigathi Gachagua had placed his hopes in the courts, noting that he was not going to get justice before the two houses of parliament. And hours after the Senate ratified the decision by the National Assembly to send him packing by way of impeachment, Gachagua's lawyers and allies were in various courts in the country, hoping to save him from the ouster. In a petition filed through his lawyers at the High Court in Milimani, Justice Chacha Mwita granted, among other prayers, an order that, due to the issues raised in the petition and application, and the urgency demonstrated, a conservatory order is hereby issued staying implementation of the resolution by the Senate upholding the impeachment charges against the petitioner, the Deputy President of Kenya, including appointment of his replacement until 24th October 2024, when the matter will be mentioned before the bench to be appointed by the Chief Justice for appropriate orders and actions.
The resolution is suspended, right? The resolution impeaching the Deputy President is suspended, is stayed, which means it's of no effect. You get my point? This is what the court has said. Now, and I'm saying that thereafter, right, these other processes are affected by it, right? Remember the appointment, and I still maintain the appointment itself is a process. It's a process, and this. So we have got the orders which came in at 1358, right? Before the swearing in. So you see, the swearing in has not taken place. So this order has stayed whatever process which was going to lead to the appointment.
But it is orders given by Justice Richard Mwongo in Kerugoya that have definitively stopped Deputy President-designate Professor Kindiki Kithure's inauguration, initially set for tomorrow, Saturday, the 19th of October. In the case filed by David Munyi Madenge and Peter Gishofi Kamotho, Justice Mwongo has directed that, among other things, that in light of the nature of the matters raised herein, as noted in Order 3 herein, conservatory orders are hereby issued against implementation of the resolution of the Senate in terms of prayer C of the notice of motion. preventing any person, including the second interested party appointed by the president and approved by the National Assembly, from assuming the office of the deputy president. That second interested party is Professor Kithure Kindiki. Gachagua's lawyer Victor Swanya says that in light of these orders, he remains deputy president.
The courts have said that this process has been stayed. So it means that the deputy president, Honorable Rigathi Gachagua, he is the deputy president. So it's up to the government to ensure that these orders are followed, and if they are taken away, his security must be restored. They still have responsibility for his security as the deputy president of the Republic of Kenya.
3 other petitions had been separately filed challenging Gachagua's ouster at the High Court in Milimani in Nairobi. They include petitions by Eddie Waigoro and Victor Ngatia versus the Senate and the National Assembly and 10 others, Andrew Njoroge and Mwirore Waweru and 1 other versus the Speaker of the National Assembly and the Speaker of the Senate, and Emmanuel Elijah Otieno versus the National Assembly. Ibrahim Karanja, NTV.
Let's unpack what we just had from that news clip. Oh, I'm so excited today. Please like this video and subscribe to this channel, because today this is going to be an important session where I want a panel of experts in Kenyan law to join me, because we are going to talk about what just transpired today. I will give you my take on this. You had that clip from Nation, NTV, whatever you want to call it, that news clip. I think you saw it, okay? Now, hold up, wait a minute. Kachini, we are about to discuss. Kachini, let me start with this. The courts, the high courts, has given a what? What do you call it? A conservatory order. Conservatory what? Order on the issue, on the matter, on what was done, what transpired. The Senate, remember, the Senate went ahead and they did their cross-examination, but there's a few things that they didn't do, which was constitutionally supposed to be followed as far as the procedural events was to take place, as far as the procedure into taking out the regarding Gachagua. But that's not where I want to touch on first. I want to just the fact that this court, the High Court, said that basically, let me interpret it in the layman's language, okay? So you can get it. Let me interpret it. Are you ready? Let me interpret it in the layman's language. Basically, what the court says is this. Hold up, stop everything. What happened at Senate cannot go on, and it cannot be recognized. Stop it. Whatever vote you did and you say that you've impeached it, it's null and void for now. Stop it. Because we have reason to believe that there were incidences, procedural anomalies contrary to our 2010 Constitution, as it spells out what needs to be done in order to impeach our deputy president. Oh, ashabalala saba. Come on. Subscribe maramoja kabla sijaanza, because today is the day of salvation. Ama namna gani? Today is the day of salvation. Ndio nawaambia, wacheni, stop being excited over nothing. Kuna ile makelele ya politics mnafurahia hapa. I'm not here. Hey, let's meet a disclaimer. Quick disclaimer hapa mara moja before I get to anything. Quick disclaimer. I never voted for Gachagua. I never voted for Ruto. I never voted for Raila. I never voted for Gachagua. I never voted for that Ninio. Never. But what I really voted for and I co-signed to is the 2010 Kenyan Constitution. Listen, you can say all politics all you want, and I hear this argument. Let's just deal with it right now. There's this silly argument that I hear from people when people say, "Oh, this is a political process. This is a political process. Oh, we just don't need to come up with evidence. This is a political process. If we just have a reason to believe that the deputy president committed all these things, that 11 grounds that were presented by Mutuse, oh, that's good enough. We should let. No. Hold up, wait a minute. What does the Constitution say? I want to give my listen. I will try to restrain myself from giving you my view on this issue because I want you to hear it from the experts in Kenya first before I give you my view. My dear friends, that's what I'm telling you. Kindiki Kithure might be set up for a monumental, biblical, gigantum embarrassment, because the court will most likely overturn this thing. I don't have to be Justice Koome to know this. I don't have to be Justice Witter. I don't have to be Justice Chacha. I don't have to be Justice Witter. I don't have to be Justice Wanjala, Smoky Wanjala. I don't have to be them. Based on the evidence and the procedural nature in which Gachagua was impeached, there was gross violation of the 2010 Constitution that we can pinpoint by highlighting the articles in the Constitution that can suggest that will explain why this man never got a fair trial. He was hanged by a kangaroo court. He was hanged by incompetent, politically motivated imbeciles that call themselves members of parliament and senators in the legislative body of Kenya. Listen to me, oh children of Kenya. Subscribe maramoja before I get started because I'm just getting warmed up. Subscribe now, like it. I want 1,500 people today and I want 150 likes. Go like the video. Subscribe right now as we get started. We are getting started. We are just warming up. Hata sijaanza. Unajua hata sijaanza. See, I haven't started. Should I bring Justin Onsogo? What's his name? That lawyer Onsogo or something. Let's get started. Let me play another video because I'm just warming you up. Sijaanza kupika. Sijaanza kukoroga. Sijakata kitunguu. Saizi nimeweka tu stove ianze kuwaka. I haven't started cutting the kitunguu. I haven't put. Hey, Wanjiku, I see you over there. Tafadhali, like the video maramoja. Now subscribe because we are going to get loyally. And if you're a lawyer in Kenya and you have expertise, okay, in law in Kenya, kuja hapa in constitutional matters because this law is broad. You can be a family lawyer, family divorce lawyer. Kuja kama if you're a lawyer in constitutional matters. Come here. We want to talk to you. We want to discuss what is happening in our great Republic of Kenya. Oh, mko ready? Haya, tuanze. Mko ready? You guys are not ready. Ubayenu nyia mko ready. Mko ready? Haya. Let me start. Let me show you something else. Okay? Okay. Okay. Hey. All right. While I do this, ebu anzeni kuninio. Anzeni ku subscribe na muninio. Na mufanye nini? Na mulike, okay? Because I'm about to show you something. We're about to talk. We are here. Unajua leo ni weekend. So tutaenda ile we shall go in the Muko ready lakini? Muko ready? I don't think you are ready. You are not ready. Haya. Twende. Let me show you something. Twendeni. Hold on. Wait a minute. I'm going to give you my view after this. Hold on. Okay, today. Like the video, like the video. Let's watch this clip. It's a bit lengthy while I gather my thoughts. We shall go to the Nino.
Dr. Maxwell, from what Willis has mentioned, 149 talks about the voting of the nomination, while 137 talks about the vetting of the candidate. Do you see it the same way?
I think I should insist that contextualist reading of the Constitution is far better than a textualist reading. I do agree with my colleague, of course, my senior, that, of course, you cannot read any provision of the Constitution in isolation. You must read in the dictum of Tinyefuza but the Republic, the provisions of the Constitution in a way that one sustains the other and does not destroy the other. And this is exactly what I'm talking about. If we had to read Article 137 in such a way that it sustains, or does not destroy Article 149, this is what it would mean. That there has to be a distinction, and a clear one, between election into office and the filling of a vacancy. Okay? So that one does not apply the requirements of a candidate when it's election time to the provision of the Constitution that governs the filling of a position, especially when that discretion is conferred on the president. Now, election regime actually should be different and differentiated from a vacancy regime. That is what I call as a contextualist interpretation of the Constitution, such that these provisions sustain each other. If the Constitution intended that there was to be any entity, EACC, by the way, in fact, before we come to IEBC, before anybody is nominated and vetted by the IEBC in election time, there is the EACC involved, there's the Higher Education Loans Board involved, there is the DCI involved, and all these background checks and certification that one needs to present to the IEBC, then IEBC approves, then nominates. In fact, that is the Article 88 role of the IEBC. Such is not to be found in Article 149. You see, you cannot jump the gun. If election requires all these certification and clearances before you go to the position, before you go to the IEBC, why are we only insisting on IEBC when it comes to the filling of a vacancy? If one was to interpret the Constitution, it will be a negation of actually the powers conferred on the president. In fact, we should read Article 149 as what we traditionally call in constitutional law as a prerogative of the president. Filling a vacancy, the president has a right to choose anybody to become the deputy president as long as he meets the criteria. Okay, and those criteria you'll find in the national governance, the principles of national governance and leadership, you'll find them in the leadership and integrity. Okay, of course, without negating the Article 137 requirements of a person who should be president or deputy president. I am emphasizing the point that constitutional interpretation, okay, should not be made to be so ambiguous and should not be complicated and obfuscated by requirements that cannot even be infused into the reading. What my colleague is actually doing is what we call in constitutional law as reading into the provision of the Constitution. The concept or the idea or the notion of reading in only applies to legislation. And you know very well that legislation or a regulation is always very inferior to the Constitution. Judges cannot be permitted to read into a provision. Okay? So I do not see the requirement, the involvement of the IEBC. If they indeed have to be involved, then you have to start from the very beginning. DCI, HELB, all these approval bodies, which is not in Article 149. If it is, then he should point to us. And I think he's also splitting hairs. The vetting and the voting. Okay?
Yes.
Article 49, when it talks about voting, unless the language is so ambiguous, the intent, the purpose, and the purport, which we call purposive reading of the Constitution, they do not just vote and then they sit on the vote. The vote has the purpose and the objective of approval. Okay? And one should actually not just go and vote because it is Kindiki or it is the Rigathi Gachagua or Maxwell Mia. No, it is expected that, like any other person, when you're voting, you're exercising your conscience, you are exercising objective judgment. And the objective judgment will look into all those considerations that he's perhaps talking about. IEBC does not just vet. They vet to ensure that one meets the constitutional requirements. For example, even the moral rectitude that the Constitution requires under the Leadership and Integrity Act and the provision of the Constitution. So that Parliament is now conferred the role in context, the role of what any other agency should do in the circumstances when a vacancy arises.
Okay, I want us to move on from this issue, but I know Willis wants to rebuttal. Even as we do, I just want to prepare my team to just give us that soundbite of the Senator Okiya Omtata, but your final remarks on this IBC issue.
Let me say this. You know, my colleague is struggling with reading the Constitution. I heard him talk about, in fact, how he explains it. This will be a very good argument during the Moi days, where the Constitution always deferred to the president, or the law deferred to the president. We are now in 2024. And we have a 2010 Constitution. And one thing that he misses by a mile is to say that in terms of criteria, the qualification, you'll find in Article 10. Article 10 of the Constitution is merely prescriptive of the national values and principles of governance. It does not set anywhere the qualifications of a deputy president. Then let's go further. When he says that the work of Parliament is to vote and to approve, when it comes to the question of elections in this country, where a vote is involved, that you are going to process a nominee to a public office.
Yes.
Article 88 vests that responsibility on the IEBC. So in terms of Parliament, National Assembly, voting on the nomination of the nominee, you presume that that nominee must have met the minimum criteria before his name is forwarded. And where do we find that minimum criteria? And the criteria is to make sure that the time you're holding office, this applies to you in office if you succeed. One of them, they are found in Article 137. One of them, you must be a citizen of Kenya. You must not owe allegiance to a foreign country. You must be a university degree holder. All those qualifications. And the things he's referring to, I must make it very clear here, as a former prospective presidential deputy president running mate. HELB, DCI, they have not all. The qualifications are those which are found in 137.
Okay, but law is subject to interpretation.
Yes, and those qualifications, in my view, applies to you because it means that by the time you sit there as a deputy president, we will know what is your minimum qualification. Yes, you're a citizen, you're not a Ugandan. You belong to a political party. You subscribe to the code of conduct. All those qualifications in 137 are with you when you sit in that office. But the route that my colleague is suggesting means that if you leave it to what he calls the unfettered, we are trying to fetter the discretion of the president, then is it trying by implication to say that the president can nominate a Ugandan to go and take the name to Parliament and Parliament votes for it because he's the one who did the vetting? That vetting is done by an independent body. That the question of eligibility is a question that vests in IEBC. And to his credit, William Ruto, in attempting to meet that, went to IEBC as he presumed it exists, and he got a clearance letter from Marjan, clearing that Kithure Kindiki meets the minimum qualifications. All that I'm adding to the conversation is to say this. To the extent that you went to IEBC, which IEBC did you go to? Because according to our laws, according to the interpretation of the laws that the courts have given, including the Supreme Court, IEBC is only properly constituted and to be able to perform its functions when there's a chairperson and commissioners.
All right. So, of course, the courts will rule on that. And, of course, we'll continue with this discussion on the IEBC because you each have different opinions on that. But the former deputy president, Rigathi Gachagua, is hoping that the courts will save him, giving a political lifeline. I just want us to listen to what Senator Okiya Omtata said.
Before I go on to this, please take this moment to subscribe to this channel and like this video, because we're about to break down the illegal nature in which Gachagua was not only removed, but the illegal nature that they're bringing. They want to force Kindiki to become the new deputy president of Republic of Kenya. Now, Ruto went to Mr. Marjan, somebody from the IEBC, to write a letter and say that this letter is from the IEBC to represent the IEBC, clearing Kindiki to become the deputy president of the NINEO. What Ruto failed to understand is that there's a judgment that was out there that the Supreme Court gave and said that you cannot nominate or have an election or have anything to do with IEBC if they don't have a what? A chairperson of the IEBC or a what? Or commissioners, which we do not have. So, by what method did Marjan conduct a thorough vetting of this Kindiki guy? Because the vetting is supposed to be done by the IEBC. Article 88 basically say that in even Article 7, if I'm not wrong. Listen to me. The vetting of any nominated person by the president should be done by the IEBC. And the vetting cannot be purported to have been done if the IEBC does not have a chairperson and the IEBC doesn't have a what? Doesn't have commissioners. So that is the first strike. Okay? So let's listen in as the rest of it.
During this particular process.
To remove the deputy president, the provisions of Article 144 and 145 relating to the removal of the president, the deputy president of the president, shall apply with the necessary modifications to the removal of the deputy president. The Constitution does not anticipate a situation whereby we apply Article 145 on the removal of the deputy president without modifying it. The phrase is, shall apply with necessary modifications. What modifications has this House made, or the National Assembly made, or Parliament as a collective made to Article 145 before applying it to the Deputy President? Can we impeach the Deputy President using the standard for impeaching the President when we know very well that the President is immune to prosecution? And therefore, the certain standards that apply to him won't apply to the Deputy President. So given that the Deputy President has not enjoyed those immunities, how are we protecting him? How are we ensuring that this process is constitutional? It's my submission that on the modifications to Article 145. And you have seen the potholes we have fallen into. It's okay for the president because the president is immune from judicial processes. But is it okay that the deputy president should be prosecuted using the same standard used for the president?
So he argues that that particular process, the entire process, is flawed because there's need to make modification of Article 145. Is that the case? Let's start with that.
I think Okiya Omtata's reading of the Constitution is a layman's language. It's a layman's interpretation. The word modifications, I think, has also been used there in context. So it's a word that requires only interpretation and not application. In this sense, the Constitution requires that, the Constitution anticipates that the office of the president is different from the office of the deputy president. So that when you are applying those two provisions, Article 144 and Article 145, you contextualize it in your own interpretation, knowing that this person is the deputy president, but the circumstances, the requirements, the provisions, the meanings should apply only when the situations may be necessary. It does not envisage the lessening of standards, the dilution of standards just merely because this person is sitting in the office of the deputy president. It does not anticipate different standards. It does not anticipate different requirements for removal of the office of the president. In fact, the grounds for removal, if you read the provision governing the removal from office of the deputy president, Article 150 reiterates those that are provided in Article 145, which of course is gross misconduct, the breach of national or international law, or the breach of the Constitution. Those are the three tripartite requirements for removal from office of the president. It is not anticipated that when you are interpreting those standards, you will modify them to fit the office of the president in such a way that you will lessen the standards, or you lessen the requirements, or you lessen the tests that need to be met. So I think Okia Omtata's, of course, that's a political language that he was using in the House, perhaps to dissuade the House to perhaps insist on probably not higher standards, because the office of the deputy president is far below that of the president. No. The constitutional requirement, those tripartite requirements, can only be applied actually to the hilt and to the teeth. Okay? So the political interpretation should not actually infiltrate the constitutional interpretation. If I was the National Assembly, and I think that's why, in one way or another, I think the process yesterday by the National Assembly was actually a political process. Only today, then, they became aware and alert to the constitutional standards, the constitutional requirements that they tried to adhere to. And I think that's why Deputy President Rigathi Gachagua has beaten them to their own game. The constitutional requirements, needed to have been proved. For example, if one breached the Constitution in one way or another, that ought to have been tested before the Senate, before the National Assembly, and that you give the Deputy President a chance to defend himself. Okay? So the fact that the Deputy President, in the same way as the President, ought to be given a chance to defend itself, that cannot be read with any necessary modifications. Okay? It's a constitutional standard that has to be adhered to.
Okay. Willis, coming to you, staying with what happened yesterday, that issue of asking for an adjournment of that particular sitting to Saturday. And many Kenyans are asking, what was the rush? Perhaps maybe you can explain, would the Senate have suffered any prejudice by adjourning that particular sitting?
Let me say this. The Senate, if you look at how it conducted itself, it misunderstood the law. Because what the provisions of Article 149 require is that the National Assembly submits a name within 2 days. I mean, the motion within 2 days. They submitted their instruments of impeachment within the 2 days. Then it provides that the Senate can form a special committee to conduct investigations. The investigations must be concluded within 10 days. So what ought to happen was investigations.
Not the entire process.
Not the process. Then they are supposed to now prepare a report. That report makes a recommendation. If it makes a recommendation that no impeachment, it ends there. If it makes a recommendation that you impeach, then you table the report before the whole Senate. And the Senate will require, again in Article 149(6), will require the Deputy President to appear before it. And he has a right, the wording of the Constitution, he will have a right to be heard and to be represented. So what ought to have happened in the 10 days was purely a question of conducting the investigations. The Senate, when they moved the motion of a special committee, they adopted to take the route of converting the entire Senate into an investigations committee. So if they had understood their role and drew every stage of this process, they would have known that the 10 days referred to applied to investigations. The Constitution has not told them which timeline within which the report must be voted. So there will have been no prejudice, there will have been no constitutional crisis, if any, if the Senate extended by a day, as suggested by the Speaker, to reconvene on Saturday to hear the Deputy President, or even the following week, or even after 2 weeks, because there is no timeline given to them when to vote on the report of the investigation.
Consider that there is no timeline as to how long the Senate should vote on this issue of impeachment, but what they should have done is to have a committee of 10 or I think it's 11 people, which once it's formed, it has about 10 days to investigate the matter. And by investigation is, for those of you who may be slow, by investigation, it means they were supposed to ascertain as to the motion, if it's true. If they say there was suspicion of money laundering by Rigathi Gachagua through his 22 companies, they were supposed to ascertain, to find out, investigate, see if that Mutuse was trying to get us to believe. I will repeat again. To go to his Willis Otieno's point, I'm saying this. Instead of rushing through the plenary to vote the deputy president out, what the Senate was supposed to do was to do what? Was supposed to create this committee, and the committee has 10 days to investigate if the motion that Mutuse is leveling against the deputy is true. And this committee has 10 days to come up with a report about the investigation on the accusations about Rigathi Gachagua and present it to the plenary and tell us where is the evidence, which they did fail to do so. Now, another gross violation by the Senate was the fact that, okay, Mr. Rigathi Gachagua was sick, or some of you might suspect that it was a fake ill. He faked his sickness. But nevertheless, what they should have had is because, as you can hear, the Senate has no timeline in which they can vote on the issue. So if Rigathi Gachagua claimed to have been sick, what they could have done, what was prudent thing to be done, was to give it time, see if he can recuperate within a certain time, okay? And if he can't, then he can use representatives. But the law, under Article 145, it says that Rigathi has the right to physically be present at the Senate to be cross-examined. Okay? Listen to me. It's a right. It's not a negotiation here. This is a right. So if you don't give him time to show up physically to be cross-examined and to represent himself, then you do violate his right of representation and right to a fair trial. That's why I'm saying, when this thing goes to court, my friends, no wonder the court has ordered a conservatory order to stop Kindiki from assuming office. What a gross misstep by the Senate and the National Assembly. But let's listen in to this lawyer as he continues. Ladies and gentlemen,
So
as I continue, do not forget, all of you that are watching, subscribe, hit that subscribe button, hit the subscribe button, and like the video, subscribe and like the video, subscribe and like, because I want to bring the top lawyers in this channel so we can interpret what is going on. I don't need Orengo to interpret this. As a layman who can read and write, I can tell you what's wrong and right. Okay, but like the video, subscribe all of you as we continue going on. Listen to the lawyer.
How far would they be able to stretch it?
So, I mean, and then go back. I want to take you back as a close of that. I want to take you back to certain rights that were being infringed in this particular instance. In Article 25 of our Constitution, we have what we call absolute rights. They're absolute. You can never take them away. And they are largely on the person too. The right to be heard, fair hearing, and habeas corpus. You cannot infringe. These are called, in fact, I normally refer to them as, these are superior rights, even to the Constitution.
Okay.
Because the Constitution has elevated them and said they can never at any given time be infringed. Now, if the Senate is saying we have an administrative timeline here, which they've misinterpreted in the first place, that tells us we must conclude within 10 days, they must ask themselves, but what happens to his Article 50 right to be heard, which is an absolute right under Article 25. We must give the opportunity so that even if this matter went to court, the Senate will have a strong argument to say the timelines were going to conflict with his right to be heard, because nobody can predict illness. And the fact that he was ill, that's a very valid reason. If somebody is sick, you cannot proceed without him. You cannot force a sick person to attend to hearings.
Okay.
Many a times, in fact, they always say that the easiest way to get an adjournment in court, that even your colleagues don't oppose an advocate, is when you or your witnesses are sick. Okay. It is accepted. And then the opportunity will come. So the only thing Gachagua will have benefited is maybe just kick the can down the road for another extra 1 or 2 days. But his day with destiny, it was predetermined. He was going to go. And even now, as we are going through these legal questions and discussions, Gachagua's day with destiny is here. He's just stretched it a little. He will still be voted out by the same Senate, because don't think that these people were giving him in terms of trying to even pay attention to the evidence and the reasons why they want to impeach him. That was a political question. All that we are saying, I'm saying in particular, is that in pursuing your political objectives, please adhere to the Constitution. Follow the law at any given time. Okay. And that is important because of this, as I conclude. It's important that when all else fails,
the takeaway from this, the most important thing that Mr. Willis said, that Article 10, there's some guaranteed rights. And part of the guaranteed rights is the right to habeas corpus. Habeas corpus. Habeas corpus. Habeas corpus simply means, for all you ladded friends, produce the body. The body should be there. The body should be produced. That's Latin word. Oh, shabalalas. Today we are about to get in. Oh, I'm cooking today. Please subscribe if you haven't subscribed. Listen, if you're new to this channel, please subscribe to this channel and like it and share it to your friends. Tell your friends, today we are cooking. All this, don't be fooled by all this cloud of political talk by these chatterheads who are saying it's over for Gachagua. It's not over. And I don't support Gachagua, but I support the rule of law. If you're going to impeach him, do so in the legal manner. Don't lie. Don't skip the steps. That's why it's an oxymoron when people come and say that this was a political process and not a constitutional process. Well, it is a political process, but in order for it to be executed fairly and squarely, you have to follow the law. And the law was created, mirrors what the Constitution says. You understand what I'm saying? Do you get the point, my friends? Okay, let's get back to there. So what I'm saying with the right to habeas corpus means that Rigathi has the right, constitutional right, to show up physically, because corpus means body. So it is touching on Grigadi showing up in court physically to be cross-examined. But when it was announced that he was sick, Senate did not even afford him 1 second. Instead, they fell to the trap and said, let's go ahead and impeach Rigadi, because it was already had been discussed by the ODM dimwits and the UDA dimwits, who know nothing about the law. Only a few knew the kind of trick Paul Mwite was setting them up. Now look at the fools in the morning, how they were cheering when the National Assembly, all of them, voted to bring in Kindiki, not knowing how the law works. Oh, Shaba Saba. Like and share this video. Oh, subscribe, because we're about to get started. Let's finish this clip as we go on. Oh, I'm so excited. Today is Friday. We are going to go marathon.
When people are pursuing their personal interest in politics, our only anchor becomes the rule of law. And the law guarantees everybody a predictable future and certainty as to what needs to be done.
Okay, coming to you, and let me take you back to Wednesday when we saw that 3-judge bench rule on the issue of separation of powers and the doctrine of separation of powers. So in this particular process, it is a political process. So who is in whose business?
I think one important thing that really needs to be understood is that the impeachment process is an administrative process, because it determines the right of an individual. So that when the Senate or the National Assembly sits to impeach a person, it's an administrative process that the court can intervene on. The argument that the court cannot interfere with the political process is not viable. It has no constitutional basis. All that one needs to demonstrate when they go before a court is that an institution that either sits as a disciplinary body or as an impeaching body, which of course it involves the removal from office, and the process itself has affected my rights in one way or another. So I think Gachagua was right to go before the court and complain about, in one way or another, the violation of one right or the other. So that the court refusing to grant an order does not mean that the court is actually keeping away from highly politically volatile decisions. The High Court was just saying perhaps that you have not demonstrated any individual right that has been infringed in one way or another. And I think Gachagua must have gone and reflected very, very deeply that if I was not able to demonstrate this right, and I think
this man is an charlatan. The court did not stop the process, not because Gachagua did not produce enough evidence for them to produce, to have an injunction order or a conservatory order. The court simply cited the concept of trias politica. The trias politica is the concept of separation of powers. You understand what I'm saying? The concept of the separation of power. So if there's a process of impeachment which the National Assembly and the Senate, which constitutes the legislative body, has the mandate constitutionally to undertake this process of impeachment, the courts should not intervene until the process is concluded. Oh, Shaba Saba Soba. Now that it was concluded, because remember the National Assembly move on with the motion that Gachagua should impeach. Then the Senate went ahead through their kangaroo court. Ideally, the Senate was to conduct a quasi-jurisprudential function, because you have to cross-examine the accused and have an investigation through an 11-man panel, which in turn should come and give a report on what they found regarding the motion. Then the vote shall take place after that. But all this never took place. Okay? So the court said, we shall wait till the legislative body finish their job as it is mandated by the Constitution. Then once they're done, and that's why Justice Mwilu spoke yesterday and said, we shall let it go on at the Senate, and after that, we can pick it up once the legislative body finishes with their constitutionally mandated function. That's why they had to wait. But it was never, because it has nothing to do with Gachagua not having a case. Sorry. Hold on, ladies and gentlemen, brothers and sisters. Let me continue.
The Senate should also have thought about this very, very deeply. So they resorted to a political process and a constitutional process. And look, Gachagua actually beaten them. And probably this war, this contest and contestation probably will be with us for at least 1 year. For the very, very simple reason, they did not accord Gachagua a right to be heard. That right cannot be limited under the Constitution. I think it was premature for Gachagua to go to court before the National Assembly even started the impeachment process, because at that time he was not able to demonstrate any right that was violated. Here in this particular case, Gachagua can actually demonstrate the Article 145 5 infringement,
Yes,
where he has not been heard. And indeed, the rush by the Senate to conclude the impeachment process did not properly reflect on the constitutional requirements. The Senate, of course, has got very honorable professors of law, Professor Jenda and the rest. They ought to have read the Constitution such that, in such a way that they could not have given Rigathi Gachagua a lifeline. Actually,
Okay.
they have given Rigathi Gachagua a lifeline. The National Assembly today tried by ensuring that the voting process is transparent. You know, the people can see what the National Assembly is doing, who voted for what. In fact, the entire House voted in favor of Kithure Kindiki. But that is only after censure and warning from Otiende Amolo. How is it that the Senate missed such a critical process, such a critical constitutional test, critical constitutional requirement of having somebody to be heard? And I can tell you for certain that Rigathi Gachagua probably will have the last laugh. He may have the light of day, for the reason that not having been heard is a violation by the Senate. The Senate, of course, one would want to say separation of powers, the executive on this side, the Senate, the parliament and the judiciary. It is a critical constitutional question that when you are sitting in to remove somebody from office, you are sitting there as an administrative body. They are not sitting there as a legislative body or as an oversight body or as a representative body. They are actually taking an administrative action that affects the rights and the interests of an individual. Where such happens, the law requires that you must accord somebody the due process that will be required even in court.
All right. We're out of time, gentlemen, but briefly, in 30 seconds each. And Willis, even as you give your final remarks, Many are saying this is a constitutional lacuna, is it? And if so, what happens in the case?
In my view, there's no constitutional lacuna here.
Okay.
The political hotheads are just trying to throw so many words and interpretations and to come up in a way just to muddy up the conversation. What to me is a very clear process. The courts are seized of this matter. The courts have issued orders. The courts are there to interpret. I mean, what else are we spending so much energy saying, oh, we'll swear him in, we'll do this? Just go to courts. Let the court decide. And these arguments that you are calling constitutional crises, they'll be made in court, I believe. Okay. And the courts will issue an order and life will continue. The crisis that exists is a political crisis of somebody who maybe hoped to reconstitute his executive in a way that he wanted by a particular date. That's the crisis of leaders, not a crisis of the people of Kenya. The people of Kenya care about Adani, SHIF, SHA, JSS, the universal healthcare workers who have not been paid 6 years, are not earning half their salary. They are not even getting that. And these are the people who are the frontline workers in terms of saving the lives of Kenyans. So me, I don't believe we have a constitutional crisis.
30 seconds.
I think as we speak, we have no person sitting in the office of the deputy president. Rigathi Gachagua has been impeached. So he's not the deputy president. What the courts have stopped is the appointment of a new deputy president. There is a vacancy in the office of the new, in the office of a deputy president. But I think going forward, of course, this is now political speak, anybody who will sit in that office going forward from the time when the new deputy president has been appointed, one thing that they really have to deeply internalize is the question of making critical alliances in politics. Don't attack the executive as a lone ranger.
Okay.
That's what the deputy president, Rigathi Gachagua, did.
All right, thank you so much, gentlemen, for making time to just come and share your nuggets of wisdom with us in regards to matters law. Of course, you know, law, as they say, is subject to interpretation.
Ladies and gentlemen, brothers and sisters, friends, enemies and comrades. Now, listen to me. Listen to me carefully, because now we want to get to the articles of the Constitution. You know, there's one thing to hate Rigathi Gachagua. There's one thing to dislike him for whatever reason, whether his politics or the way he looks, the way he speaks, what he says, his demeanor. But it's another thing to look at the law as it relates to this whole process of impeachment and say, yes, there's enough evidence to remove him. That's another story. I can care less about his personality. I can care less about his politics. I can care less of what region of the country comes from. I can care less his political affiliation or persuasion or philosophy. But we have a constitution that spells out how things should be done, conducted. The main fight between these two lawyers in that clip that I played, the main contestation, which was later brought to light and settled in a subtle way by Willis Otieno, was this idea of, does the National Assembly has the authority to vet a nominee that has been nominated by the president? What is the role of the IBC in this whole process? Or do they have a role at all? That is the question that these guys were actually basically debating on. And also, what was also being debated was there any procedural inconsistency during the impeachment proceedings, whether by National Assembly or by the Senate? And lastly, the question is, was there a violation of Rigathi Gachagua's rights? Oh, Shaba Saba. Those are the 3-4 weighty issues that needs to be answered in this whole process. Now I can give you a quick answer. Hey, oh, but I will wait because I want you to get a full understanding of what is going on in Kenya. How, Shaba? Do you hear me? Go ahead and subscribe to the channel. Subscribe. I take a moment before I get to the nitty-gritty. And I will bring people here. If you want to come in, I will bring you here. But take one moment and hit that subscribe button, because this channel is not a channel where we just go by emotions. You know, if I want to show my emotions, I can come here and show my emotions. I am an emotional being. I can show you that for 5 hours. Crying, laughing, jumping, whoa, 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 whoa. But that doesn't mean squat. It doesn't help you to whip up your emotions against or for an issue. What matters is the truth, because the truth shall set you free. A lot of people try to fight the truth, but that's okay. You can fight it. It comes in later. I was here when I told you Morara is a cornball, is a freaking con man. Oh, now it's becoming more clear. And there's some people still following him and they're offering money, which is okay. It's your individual right to support anybody and everybody if that's the case. I warned you about Mr. Caswell. I told you he was an empty suit, not to be fooled by his perspicacious response when asked in interviews questions on matters politics. Don't be fooled by how someone dresses or how looks. It is all about the content of a man. What are you made of? And we only find out in times of desperations when you're under duress. Let me not waste your time, ladies and gentlemen. I want to read something that's been happening today, that happened today, because we have to contextualize what I'm saying. So take a moment and subscribe to the channel. As before we go up, take a moment. Finya your subscribe button. Finya your subscribe button. Now like, because I want to give you something that you can use and actually you can benefit from. Mnanisikia? Okay, so let's establish some things today. Let's establish some things that we need to establish today. There's a court order. There's a court order. What does that court order do? By the way, do you know who's supposed to be present during Kindiki's swearing in? Martha Koome, the head of the judiciary or Supreme Court, whatever the case you want to call it, or JSC. She's supposed to be present. Will she be present while there's an active court order that basically has nullified, stopped the whole process? That's a question for another day. If you want to, we'll discuss it. If I'll open the lines, I will put the link, and anyone that wants to speak about this, we shall continue and we shall talk about this. But let's go on. Let's go on. Before we get to the other stuff. All right. There's a court order. Let's get in. Please. All of you that are watching, all of you, not even one, all of you that are watching, if you are not subscribed, go ahead and hit the subscribe button so we can go on, and like button at the same time. Okay. And share it with your friends, brothers, enemies, and comrades. Let's get to the nitty-gritty. Here's the letter that the court actually wrote, and I will read it loudly, slowly, so we can all get it and appreciate it. Ama namna gani? Can you see it on the screen, ladies and gentlemen, brothers and sisters, friends and comrades? Because it is one thing if we are going to talk and argue, but we have to contextualize what supports our argument or merits or demerits. Okay? So here's the letter. I shall read it and we shall understand it. Whether we don't understand it or not, we shall bring a lawyer if we need to. All right. Republic. Hold on. Let me put it bigger so you can see it. Hey, msianiharibia jina hapa. All right. Simulaiona ama muyoni? Kama muyoni ni shauri yenu. Aya. Republic of Kenya in the High Court of Kenya at Nairobi City. Court name Milimani Law Court. Case number HCCHRPET /E565/2024. Citation: Rigathi Gachagua versus State Law Office and Senate and 3 others. Orders, court document. Listen to me and listen to me carefully as I read this letter. Hallelujah. Oh, Shaba, I'm about to start. Woo, 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 woo. Oh, la, la. This matter coming up for directions on the notice of motion and petition, both dated 18th October 2024, before Honorable Justice E.C. Mwita, and upon considering the pleadings supporting affidavits and attachments, I am satisfied that the petition and application raise monumental constitutional issues touching not only at the heart of a functioning constitution, but also its fundamental tenets of the rule of law and human rights. It is hereby ordered as a matter of urgency, that one, that pleadings be served immediately and be responded to within 3 days after service. 2, that due the significance of issues raised in the petition and application, I certify that this matter as raising substantial questions of law and public interest, and therefore fit to be heard by a bench of an even number of judges to be appointed by the Honorable Chief Justice. The file be placed before the Honorable Chief Justice immediately for consideration in that regard. 3, that in the meantime, due to the issues raised in the petition and application and the urgency demonstrated, a conservatory order is hereby issued staying implementation of the resolution by the Senate upholding the impeachment charges against the petitioner, the Deputy President of Kenya, including appointment of his replacement until 24th October 2024, when the matter will be mentioned before the bench to be appointed by the Chief Justice for appropriate orders and action given under my hand and seal of Honorable Court this 18th day of October 2024. Oh, Shaba. Penal notice. Take notice that any disobedience of non-observance of the order of the court served herewith will result in penal consequences to you and any other persons disobey and not observing same. Signed by Honorable Justice E.C. Mwita, Justice of Kenya. Doc identity has been there and number and stuff. Ladies and gentlemen, brothers and sisters, members of the jury. Can I break it down? Oh, Shaba. Oh, Saba, lala, bala, sa. Can I break it down in easy form? Basically, he's saying all that the Senate did at the Senate yesterday, all of that, and all of that National Assembly were doing today when they were talking, jumping around like idiots, talking about Kindiki is the next, let's approve Kindiki. All of that and anything thereafter is null and void until the 24th of October when the matter is going to be adjudicated on. Are we clear? Did we read the different? Read it. The third paragraph is where the meat is. Mnanisikia vizuri? Nyinyi mlikuwa mnashangilia. So as it stands, Deputy President Rigathi Gachagua is still the Deputy President. Mnanisikia? Rigathi is still the Deputy President. Hajatoka? He's still the Deputy President of the Republic of Kenya. Mupende musipende. Kindiki is an actor. Aende Hollywood. Nimasome tena. Can I read it again so you can understand it? I'll read it for you again. Kama mnataka hiyo maneno yenu. Nitawasomea tena. Msikuje hapa mniambie si msikuje. No, the court imesema tumeangalia vile hii kitu imeendelea and the petitioner has a good reason and due to the public interest tuna nullify ile kitu yoyote ilifanyika hapo ati sijui mambo ya Kindiki na sijui nini hiyo upuzi yote mlifanya Senate jana hiyo it doesn't mean anything. Imesimamishwa until the 24th of October. Well, that matter we shall be. Mnanisikia vizuri? Mnanisikia? Ama nazungumza kijarati? Haya, ingieni kwa studio mkitaka kuingia. Ingieni kwa studio mkitaka kuingia. Mimi sichezi. Sitakaa hapa. I won't be here forever. Sitakaa hapa forever. Kama mnataka kuingia muingie. Wengine mtaingia hapa mtasema na wanyimanga link. Link iko hapo. Kama unataka kuingia na useme kitu, ingia saa hizi ni wakati wako. Usikuje hapo useme ati kuna kitu kama hicho. And if you want to get to the articles of the constitution ambayo ina highlights hii kesi, by the way, hii kesi ilifanywa na watu wengine ambao hawaeleweki kimaisha. They messed up so bad it's not even funny. Let's go. Let me play another clip. Bado tuko like the video.
And just for the, just to set it off, do you feel that these court orders, some have been arguing that they've been overtaken by events? Do you feel they still are in place?
Order is like a 4-dimension court order. It is more powerful than an injunction. It is more powerful than an order of stay. A conservatory order is a 360-degree order. It applies in time, stopping what has happened in the past, preventing something to go on in the future, and even impacting the present. So when you look at the exact wording of the court on Nairobi and in Kerugoya, they are conservatory orders stopping implementation of the impeachment resolution of the Senate. What this means is that it doesn't matter how much implementation had already taken place by the time the order was issued. Any further implementation is stopped by the court order. Means that we are as if those additional actions, beginning with the removal from office, which was a direct consequence of the impeachment order of Deputy President Rigathi Gachagua, the proceedings in the National Assembly to Kithure Kindiki, all those have been stopped by a conservatory court order.
All right, so if the state were to proceed with carrying in Kithure Kindiki tomorrow as it is, they will be going against it.
In fact, they'll not only be going against the law, they'll be committing an act of contempt of court. It would be, I think, quite a serious action. Those who do it might end up finding them, and they might face sanctions from the court, including sanctions relating to their continuation in whatever public office they have. The court orders are very serious issues. They have to be complied with. And I think I also need to clarify that any action undertaken in violation of a court order is considered a nullity, null and void, and of no legal effect. It would be the same as two children playing a game of make-believe. It would have no effect regardless of who does it. Until the court order is lifted or set aside, it has to be complied with.
So what options does the government have? Is it something that the office of the Attorney General could now, step in, and what can be done if they want to, so to speak, salvage the situation from where they stand?
The way to salvage the situation is as follows. The politicians and the political process played its way out, including the quasi-judicial process in the Senate. The courts have now asserted that they have a right to review the proceedings that took place in the National Assembly and the Senate. So it is now the time, based on our constitutional architecture, for the courts to have an opportunity to review what happened. So the Attorney General would have to get lawyers, either his own staff or external lawyers, or a combination of both, to participate in the court proceedings. They can always make an application seeking to review or set aside the decisions that have been made. But that application would be heard by the 3-judge bench that is expected to deal with the matters on Thursday next week. So there are not much options between now and Thursday, because even if they were to do an application for setting aside, it would probably also come up for hearing on Thursday next week.
All right. And I've seen also conversations around Article 137, which talks about the qualifications and disqualifications elections as president. And I believe this would also apply for deputy president. And a person is not qualified for nomination as a presidential candidate if the person, that's 2, then B says, is a public officer or is acting in any state or other public office. So presuming that, considering that as far as Kenyans know, Kithure Kindiki at the point of his nomination, as well as at the point of his vote, election in the National Assembly, was still the CS for Interior and National Administration. Does that already disqualify him from being, the deputy president-elect or DP eventually?
Subparagraph 3 of the article that you've read gives an exclusion for candidate for president or deputy president. So I would not make a determination and say that that particular provision ousts the ability of Kithure Kindiki from being deputy president, because Article 137, paragraph 3 gives an exception in the case of president or deputy president.
Okay.
I think there will be a question as to whether if he was qualified to be elected, assuming that is the argument that is being used by the National Assembly to the position of deputy president, the question would be, did IBC have any role in that particular process?
Okay. And Senior Counsel, just the last one before we go, we've seen a lot of legal jargon flying around, and I'm glad you began by schooling us in regards to conservatory orders, etc. For the benefit of understanding, is there a difference between the swearing in, assuming office? There are those kind of words that at times people may use interchangeably, just for the benefit of those who may not know.
Thank you for that. So what happens is that there is a constitutional process defined that prescribes how you can become eligible to assume office. It can either be an elective process or an appointive process. The moment you have successfully gone through that process, you then become, in this case, you would be vice president-elect or vice president designate. depending on how the process took place. That means you have gone through all the constitutional steps, but you are not yet in office. You are now eligible to take office. So the process of taking office is called assumption of office, and it is a process which includes some provisions in the Constitution and in an act of parliament that has been enacted for that purpose. There are ceremonial steps, and there are also a very important procedural steps. And the most important procedural step prescribed by the Constitution is to take an oath of office. And in the case of president or deputy president, they actually take 2 oaths before they can assume the office. So the process of assumption of office has several steps, but one of them is to take the oath. And the Constitution is clear that you shall not assume office. In other words, you shall not start functioning in that capacity before you take the oath. And in the case of the president or deputy president, the oath is to be witnessed by the Chief Justice or the Deputy Chief Justice of the Republic of Kenya.
Thank you very much, Senior Counsel Charles Kanjama, for schooling us and for giving us the insights on the same and joining us on NTV Weekend Edition. As always, it is a great pleasure. Thank you very much. Like you've heard it, according to the Senior Counsel, in the event that the state moves in the direction of having the Deputy President-elect, or let me say Kithure Kindiki as Deputy President tomorrow, as things stand, that would be like 2 children having.
Yeah. What Kanjama has basically said. Hold on, ladies and gentlemen, brothers and sisters. What basically Kanjama is saying here is that woo, this is so sweet. Basically, what he's saying is that when a conservatory order has been issued, it nullifies. Oh, Shaba. Oh, Francis Irungu, I'm glad to see you. Get in. It nullifies the previously action by the Senate in this case, and it also put a halt in any process that's going on right now, which we are referring to the National Assembly, the clown show that we saw this morning when the National Assembly were very happy, gleefully voting to appoint Nania as the deputy president. And it also, in the future, if tomorrow Ruto decides to try to swear in the deputy president, his deputy president, who's not a deputy president, Kindiki, it will be an exercise in futility because the court has already pronounced itself and said everything stops till 24th of October. That's when we are going to decide if that deputy president of yours was legitimately deserved to take that post, or the former deputy, who actually is the deputy right now. He's not the former deputy because everything has been nullified, which means as it stands, Gachagua is still the deputy president of the Republic of Kenya. Okay, so as it stands, he's still in power. Oh, Shaba, you know, people, listen to me. And again, I know some people who hate Gachagua. They think, oh my goodness, you are pro Gachagua. No. We are looking at the law, what the law says. Here you had the Kanjama who basically was a Kenya Kwanza guy. He's telling you the truth. He's telling you that, listen, this is what conservatory order means. Hey, order. Hey, you're not ordering. Wait. I want everybody that's watching this and everybody that's going to watch this on repeat to subscribe. Hit that subscribe button. It's free. Whether you're watching me on X, go to the YouTube channel. My name is Kenya Revolution. As you can see the name on your bottom left. Subscribe to that YouTube channel. Subscribe to it and like it. Like this video because this is informative. You can go to other, if you go to other platforms right now, everybody, it's like they don't want to reason. They're gun-ho. They're They're driven, sorry, Kisungu. They're driven by the hate of Gachagua. But like I said, your emotions will not take you anywhere. What matters in a court of law is the facts. What does the law say regarding this issue? Let's interpret the law. What does it say about this particular issue? Not your emotions. You can go up there and say Rigathi is a thief, Rigathi ni mwizi, ameiba, aliwa watu molos, nini. That is immaterial when you come to a court of law. He is the deputy president of Kenya. What does the law says? What does the constitution says about removing the deputy president? That's all that matters. And we can debate on that. What the procedures, the procedural actions taken by the National Assembly and the Senate, what they proceeded constitutionally undertaken, that's the question. This is not about Gachagua Liba. If it's told, yes, you know what, they'll be in the court of law, you will have to provide evidence. Mutuse, you cannot go there and say, hey, no. Where's the evidence? Is here at prima facie? You have to produce evidence. And Gachagua will show up physically for those in you. But you guys were so stupid. You were caught up in this whole nonsense. Beli mlipewa pesa. Mkaenda mkarukaruka huko. Hey. You're watching the National Assembly. They were actually cheering. I was embarrassed as a Kenyan watching what we call our National Assembly behave in such matter. Disorderly. It was embarrassing. It was embarrassing, to say the least. That's what I'm saying. It is not about your emotion. It is not how you feel about Gachagua. It's about what the Constitution say. What does the law say about this issue? You don't have to like him. So it will be a great case to see, to challenge, to see if the courts, our courts, Kenyan courts, can stand up to the Constitution and defend it and interpret it so. Okay? That is what we need to establish. That's why I keep on saying, for those of you who are celebrating ati Kindiki amewekwa hapo ati sasa ndio mwenyekiti, you might be in for a rude shock next week. Mtasema nini Kindiki nani akirudi? Rigathi. And by the way, if Rigathi comes back, first of all, by the way, on the 20th, on Sunday, mi nitaenda maandamano after Chelsea beats Liverpool at Anfield. Ninaenda maandamano at Uhuru Park. Now, when Gachagua goes back after he has survived, mutasema nini? What would you say? Nyinyi ambao mmechukia Gachagua, mutasema nini? What will you say? That's what I'm trying to say. Mimi najaribu kuwasaidia hapa. All of you, can you go ahead and subscribe to this channel? Please, msiharibu wakati. I'm sweating like an old slave. So, and I don't want your money. The only thing you can do for me is subscribe to the channel and like the video and share it with your friends. Na link iko hapo nimewekea, mkitaka kuingia hapa muongee. You're welcome. More than welcome. I'm just saying, legally, Gachagua is still the DP. Nothing suggests that, there's any legal proceeding that took place today. Gachagua is still the Nini, okay? Kalonzo Musyoka was out there speaking, and if Kalonzo is Kalonzo, do we need to listen to Kalonzo? Let's listen to him. Even Kalonzo, unajua Kalonzo jumps into anything, because he's so desperate to be seen as the real McCoy. But ameshajiprove kwa ninio. I mean, he has proved time and time again that he's always on the wrong side of history. So, yeah, but he's trying to, But let's listen to him. He has something to say about this whole issue. So let's go ahead and give him his 2 minutes of fame. Kalonzo Wamsioka.
As has been said, it is historic. And it's all because of Constitution 2010, which is why we are saying he is the second deputy president. Even as we speak, he's still deputy president. So
hold on. There's not two deputy presidents. There's only one deputy president, and that's Gachagua. You see, this is why Kalonzo Musyoka just annoys me, because he wants to be Kalonzo anaenda na ni kama bendera. Upepo ikienda huko anaingia huko, upepo ingia.
I was the 10th vice president. Eugene Wamala's elder brother was what version was it? The eighth. So these things are important. It's part of our history. It's part, and we are in the process of consolidating our nationhood as a country within the community of nations. But what happened in the Senate last night was, as historic as it was, it had serious flaws. And clearly, I think Kenyans should expect a protracted legal arguments, because we didn't even discuss this with the Honorable Gachagua, but we are aware that his teams have already moved to court. It's expected. And as senior counsel, I can tell you that you cannot, the law of natural justice demands that no person, man or woman, shall be condemned unheard. And it was all there. Senior counsel Paul Mwite, leading a very strong team, were able to argue with regard to what the Constitution at Article 145, 5B says. Before the vote, before the Senate took the vote, they could only do so after affording an opportunity to Deputy President to defend himself. There were other arguments, of course, by senior counsel Jim Orengo and Tienda Molo on the other side, and Gumbe. Yeah, so we respect all of that. But truth be told, this whole thing smacks of injustice, gross injustice, political manipulation, and all of us know this is a political trial. And therefore, once again, we want to thank the senators who stood firm on both sides. We can't condemn even those who voted for the impeachment. We can't condemn. They did what was their responsibility, regardless of what may have happened in the back rooms or wherever. And then the country continues to learn a lot from this impeachment process. So once again, we wish Mheshimiwa Rigathi Gachagua very quick recovery, and we thank God that he has spared his life. He's a giver of life, and by his stripes, we believe that Gachagua will be healed. Indeed, I think he's healed. In my spirit, I feel so. So, kama kuna kitu mwenzangu angeongeza, anaweza kuongeza, and one senator maybe, ones who are on the floor. Kwa Kiswahili ndio nikusema basi, nikusema kwamba tumemwona pata fursa ya kumwona Mheshimiwa Rigathi Gachagua, naibu wa rais wa awamu ya pili chini ya katiba 2010, na tunashukuru Mungu kwamba anaendelea vyema kulingana na ripoti ambayo tumepatiwa na madaktari lakini bado ako na udhaifu, na kwa hivyo atunge hata kumzungumzia hata zaidi. Tunamtakia kila laheri, lakini huku tukizidi kumtakia uponyaji wa haraka, hatuna budi ila pia kuangazia yaliyofanyika jana kwa seneti. Tuwapongeza wale maseneta ambao walichukua msimamo wa kikatiba, lakini kama wanasheria, mimi mwenyewe najiunga yale ambayo Mheshimiwa Senior Counsel Paul Mwite aliyazungumzia juu ya ukiukaji wa sheria kikatiba na mambo yao, na hayo maneno ni wazi yataangaziwa kindani sana kwa mahakama. And we continue to insist that the last line of defense for the future of this country remains our judiciary. So we want to urge that justice reign, even though the heavens may fall, but may justice reign. May justice reign in our courts. May there be men and women able to avoid a situation of state capture, as we have said.
All right. Ladies and gentlemen, brothers and sisters, friends and comrades, it is apparent that what really transpired at the Senate and the National Assembly was just nothing more but a kangaroo court. There's so much illegalities, and I said it from the jump that if this legislative body fails, Gachagua's fate is going to be decided at the courts, and he's probably going to win it at the courts, because based on the evidence and how the behavior of the members of the National Assembly and the Senate, the way they voted and the way they was hurriedly impeached him without actually examining the evidence, no cross-examination of Gachagua, who they should have afforded time to go defend himself. This gives Gachagua a lot of ammunition going to the courts, because they will be demanding for real evidence, and not only that, not only the evidence, but the fact that they did not afford him his right to appear, right to habeas corpus habeas, being there physically and presenting himself and being question. That alone is enough to nullify everything. That's why the courts actually had to stop everything. You cannot go on with this whole Kindiki circus. Not only that, what you did at the Senate has questions that shall be examined on the 24th of October, and you can't do anything in the future. So that was prudent of the courts, as Justice Mwita already said. So most likely, by the end of this month, Rigathi Gachagua will still be the deputy president. He is still the deputy president right now. So for those of you who hates Rigathi Gachagua, please, Zoea. Unfortunately, I didn't vote for the guy, don't care about him, but that's just the facts. The rules are the rules. The Constitution says that, hey, this is what needs to be done this way. So we'll see what happens next week. As of today, I know it's Friday night. I know you guys are busy doing stuff in your Netflix and chill. I don't know, Mkoko Club or whatever what you got going on. But just do me one favor. All of you that are watching right now, just go ahead and subscribe to the channel, and subscribe. After you subscribe, like the video and share it with your friends on your WhatsApp groups, political pages. And I'll see you then later. We can break it down further on the articles of the Constitution and all that stuff. But anyway, I have things to do this weekend, so I'll see you guys tomorrow. Right? Tomorrow, tukutane kesho, right? We'll discuss more. You never know. They might... With this administration, they're acting like Kibaki. This administration is like an extension of Kenyatta's administration with the killings and the Kiburi, and also a combination of Kibaki's, swearing in people in the middle of the night. You never know with these people. Like, they are, like I said, this whole political class are one. It's a whole big con game. But anyway, I won't get into that. Please, let's meet up tomorrow. Just do me a favor. In order for us to meet, you got to know when I come in, okay? Right? So make sure you subscribe. That's number one. Step one, hit the subscribe button. Then like this video. And 3, make sure that your notification is on. So when I come in, you know that I'm in, and I will give you a chance to come in. and share with your friends so we can come here, build a community. We can talk about politics, right? Right. Even hata nyinyi watu wanachungulia. Yeah. But anyway, I have no dog in this fight. If Gachagua stays the deputy president, so be it. If he leaves because of the judiciary dropped the ball and doesn't want to follow the constitution, we'll be left. I mean, shit. We are fucked either way. So whatever. But anyway, subscribe, like, share, comment, and I will see you guys later. Peace and blessings. I'm out.